Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
In a week where we all melted, the Trades Union Congress said it would report the UK government to the United Nations watchdog on workers' rights over new strikes law. And a researcher at the UK Parliament has been arrested under the Official Secrets Act amid claims he was spying for China. Dennis and I have the news affecting local government, however. What have you got first, Dennis?
Well, Helen, up first is the defective concrete scandal case. Until the start of September, most people had not even heard about the serious concrete defects in schools and other public buildings. But the government did know, and the LGA had already raised the alarm. So let's look further into this now the bombshell has been actually dropped. In this piece, we will focus briefly on what the issue is and what the main regulatory framework is that governs this alarming situation for parents, for teachers, and for children. 600 schools have been identified by the DfE as being at risk of structural collapse. A form of concrete called reinforced autoclaved aerated concrete, abbreviated to RAAC or RAC, was widely used in construction in the UK from the mid-1950s and is now under review in light of the dangers which have been identified. RAC is a lightweight form of concrete which came into common use in the construction of government buildings, including schools and other educational and public institutions. The risks which have been highlighted relate to RAC being less durable than traditional concrete and which can result in structural failure. Roof and wall failures are typical of the problems so far. In fact, the risk of RAC-related structural failure was first identified in 2016 with the masonry collapse at a school in Edinburgh, where part of a cavity wall fell onto an area used by pupils. And there was also a collapse of a school roof in Kent in 2018, which was attributed to failing RAC. Indeed, there are reports of a case coming before the courts in August of this year. At the start of this month, the Local Government Association issued a safety briefing notice highlighting concerns that RAC was now designated as life expired and at risk of collapse. A recent report from the National Audit Office has made similar findings. Now let's look at the statutory framework. What are the key statutory provisions relevant to this situation? The Education Act 1996 places a duty on the Secretary of State to prescribe standards for the premises of all maintained schools in England and Wales. This includes the School Premises England Regulations 2012, which apply to all existing and new schools maintained by a local authority. The Education Act 2022 empowers the Secretary of State to set premises standards for independent schools, including academies and free schools, and which are set out in the Education Independent School Standards Regulations 2010. While there are two sets of regulations, the requirements are regarded as being identical. As to the construction of new schools and to alterations and improvements to existing school buildings, the Building Regulations 2010 set the standards for the design, construction and safety of all buildings and seek to ensure the safety and health of people in and around buildings, and also cover energy conservation and accessibility. The regulations require that school buildings are structurally sound and able to withstand expected loads and forces. And finally, the Health and Safety at Work Act 1974 sets out the general duties of employers, including the need for institutions such as schools to ensure the health, safety and welfare of employees and others who may be affected by the activities which take place. The Act applies to aspects of maintenance and refurbishment, emphasising the importance of risk assessments and taking necessary precautions to protect individuals. And there is a range of guidance issued by the DfE covering the need to identify defect issues, monitoring, the need for inspections by structural engineers, and the need to protect roofs from overloading. And there's more detail available in the bulletin. Helen.
Now, developed by Dr. Stephanie Snape from the Leadership Foundation, the Local Government Association has produced guidance in a framework which outlines 12 key components of effective coalitions and includes a development tool for councillors, officers and regional teams to use in developing their own local arrangements. This follows the LGA's previous work supporting councils that transitioned to no overall control. So what does it tell us? Well, it tells us to build strong foundations, don't rush the early stages, and build personal relationships. Find the common ground. Explore your respective interests, policies, values, and manifesto promises. Identify shared common interests, policies, and values, and be clear where there are divergent interests and policies. Clarify how these will be managed. Explore having a written agreement. Build intentional relationships across the groups. Think governance, which is music to my ears, I'm sure you'll agree, because governance is at risk, it seems. So here the LGA advised to invest time in developing robust, good governance arrangements and consider which political management arrangements will work. Get the right people for the right jobs. Look across the groups where possible to match known skills, experience and commitment to leadership roles. Invest time in lead member senior officer relationships and where possible, no public surprises such as public disagreements. Keep the groups involved and informed. Communication, communication, communication. Working coalitions, the LGA advises, rests on effective and timely communication, and it's hard work, but vital, they say. Learn, improve, and adapt. And finally, use political nous and soft skills such as influencing, relationship building, and negotiation skills. It's a pretty useful guidance, I think, applicable in part to situations where coalitions don't even exist. Political nous and soft skills is an interesting one. It's vital, absolutely vital, but rather difficult to acquire if you don't have them, and even more problematic when you don't have them, but think you do. Dennis.
Helen, turning now to AI. A committee of MPs has set out 12 challenges that policymakers need to address in setting terms for the governance of AI deployments. Here's more on this. The Commons Science, Innovation and Technology Committee has outlined a number of key points in an interim report on the governance of artificial intelligence, in which it also urges the government to confirm the first round of public sector pilots on the use of AI models. The report, which comes from an inquiry held by the committee, covers the current landscape of AI governance and is aimed at promoting a robust and transparent framework for how the technology is deployed. This responds to concerns around the impact of the technology on society, notably in the possible effects on civil liberties and accountability. Its 12 challenges deal with bias, privacy, misrepresentation, access to data, access to computing power, a need for models to explain their results, open source, intellectual property, liabilities when harm is done, employment issues, international coordination, and the worries about a threat to human life. The report says these have to be addressed by policymakers and that the government needs to accelerate its planned legislation to impose a statutory duty on regulators to have due regard to the principles of AI governance. It points out that a general election is expected next year, so any legislation needs to be placed before Parliament during its next session. They say this because any delay would risk the UK falling behind the US and EU and would find it difficult to diverge from their emerging models. And the report points to the government's plan signalled in its AI white paper for pilot projects in the use of AI models and tools in public services. It notes that the first tranche have been due to launch later this year and says the government should confirm detail of the first tranche in its reply to the report. Chair of the committee, Greg Clark MP, said, "Artificial intelligence is already transforming the way we live our lives and seems certain to undergo explosive growth in its impact on our society and economy. AI is full of opportunities, but also contains many important risks to long-established and cherished rights, ranging from personal privacy to national security, that people will expect policymakers to guard against. Helen.
Now, before we move on to Birmingham Council, this is the news that the panel set up as part of the government's intervention at Liverpool City Council has sent its report on the problems facing the local authority to the government for its consideration. 300 stakeholders across the Liverpool City region took part in evidence-gathering sessions as part of the panel's process. The timetable for release is as yet unknown. And so to Birmingham, which I'm quite sure you're more than aware of. How could you not be? That a Section 114 notice was issued last week, which the council advised was due to a £760 million bill for equal pay claims and problems installing a new IT system, together with £1 billion in government cuts over the past decade. The council said it does not have the resources to fund its equal pay liability and has a gap in its current budget of £87 million. Now, the equal pay claim situation at Birmingham started way back in 2007 when a group of women were successful in tribunal, but others were timed out and barred from pursuing their claim. The High Court in 2010 ruled that it could hear the claims, and this was appealed, and the Supreme Court ultimately upheld that judgment in 2012. More claims then followed. And indeed, many authorities are no stranger to equal pay claims, with many having settled over the years. And I'm sure over the coming months that scrutiny of decision-making will identify how Birmingham came to get where it is. Our very own President, Rachel McCoy, speaking to the Law Gazette at the time of the announcement, reiterated the importance that local government lawyers must ensure they are in the room when key conversations take place. Rachel added that lawyers should speak out if some proposals look off kilter and you're not convinced from a legal perspective of the value for money. If you're being told this is not a big deal, where things are being pushed through quickly, they should be on guard for anything that looks a bit unorthodox, new territory type proposals. Sage words. Dennis, what's your last item today, please?
Helen, a controversial move is being planned to bring Silex members within the jurisdiction of the Solicitors Regulation Authority. And I say controversial because not all Silex members are wholeheartedly behind this proposal. Here's more on this. The Solicitors Regulation Authority have revealed it is consulting on potential changes to its regulatory arrangements to include authorised members of the Chartered Institute of Legal Executives. This follows a Silex consultation launched earlier this month on proposals to redelegate the regulation of its members to the SRA. In July 2022, Silex initiated formal talks with the SRA to explore the potential change. The SRA board agreed that taking on the regulation of authorised Silex members has potential to deliver tangible benefits to consumers of legal services and the wider public. The SRA went on, the proposed change would simplify the complex regulatory landscape, making it easier for consumers to navigate. It would also bring more consistent levels of protection and information. For example, firms owned and managed by Silex members will have the same level of indemnity insurance as solicitors' practices and will publish the same range of information about their costs and services. The SRA's consultation, which will run until the 22nd of November, summarises the model it has proposed to Silex for the future regulation of its members. This approach includes maintaining distinct identities for authorised Silex lawyers and solicitors. The SRA said to support this, a separate code of conduct for Silex lawyers, which is aligned with the standards and regulations for solicitors, but mindful of differences in role and context, would be introduced. The SRA revealed it would also introduce education and authorization rules, setting out how authorized Silex lawyers will be authorized to provide reserved and other legal services. Nonetheless, a number of questions remain. What impact might these changes have upon practice as a solicitor? And does this move really simplify anything? And finally, might we expect some realignment in the membership of other groups as a result? Helen.
Interesting, Dennis. LLG, of course, does not distinguish between qualifications on the basis of its membership. Now, finally, taken from one of my favourite sources, the House of Commons Library, Statutory public inquiries. We're no strangers to those either, Dennis, and the library has produced a document considering the legislation. So, inquiries into matters of public concern under the Inquiries Act 2005 can be used to establish facts, to learn lessons so that mistakes are not repeated, to restore public confidence and to determine accountability. Now, within government, the Cabinet Office is responsible for advising ministers on the establishment and conduct of public inquiries of whatever form. Statutory inquiries are not the only option open to the government. They may instead establish a non-statutory inquiry, a royal commission, or a departmental investigation. The principal advantages of statutory inquiries are that they provide legal powers to compel witnesses to give evidence, provide legal safeguards, and can set limits upon the government's discretionary control of an inquiry. Public inquiries are, by their nature, controversial. At the outset of an inquiry, questions are often raised over the identity of the chair, the breadth and precision of the terms of reference, the size of the budget, the proposed timetable, and the inquiry's working methods. Now, there have been 37 inquiries under the Inquiries Act since enactment started, with the inquiry into the death of Billy Wright, the first one, and including over time such matters as the Penrose inquiry, which concerned contaminated blood. Incidentally, there have been 2 contaminated blood inquiries since 2005. The phone hacking Leveson inquiry, the death of Alexander Litvinenko, Grenfell Tower, coronavirus, Post Office Horizon, and of course, recently Lucy Letby. One little fact about public inquiries is that freedom of information legislation does not apply, as it's not a public body within the definitions of the Freedom of Information Act 2000. Section 32 of that Act also provides an exemption for documents held by other public authorities for the purposes of an inquiry. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 32, available on the LLG website now. So until then, it's goodbye from me.
And from me too. Goodbye.
Have a good week.